So as more and more foreclosure cases are going to trial, I want to talk about the critical function that discovery plays in a foreclosure trial in the successful resolution of a foreclosure case on behalf of a defendant. Now, I'm really proud to know that this firm does some of the best discovery out there in foreclosure cases. And I'll tell you, that doesn't just come from boasting internally. This is what we hear from the plaintiffs on the other side. They'll stop us in the hallway or as we're fighting over discovery. They'll tell us that, they assign a specific person within their law firm to deal with our discovery because unlike some of the other discovery that they see out there, which is a shotgun discovery, if you will, or just very broad-based questions, we ask very targeted, very specific questions in our discovery. I'll give you some examples. We don't just ask, who put the endorsement on the note or did they have the authority. We go and actually look at the physical note at issue in the file and then ask that specific person's name. John Smith endorsed the note. What authority did they have or where did they get that? Or when there are affidavits that are filed in cases, Susie Jones executed an affidavit and said that she reviewed books and records. Please provide every book and record that she reviewed, and please provide her job title and her status and what else she used to produce that affidavit. Look, we know in the era of robo-signing and document fraud and forgery and documents not being existing at the time of filing, that if we ask the proper questions and the plaintiff answers truthfully, those will result in wins for defendants. Now, I want to use one case in particular to illustrate what's so wrong both in discovery specifically, but generally in the foreclosure arena all across this state in particular. Now, I said over and over again that there's only one rule of civil procedure and evidence and rules that should apply across all of civil litigation, but we all know that in the context of foreclosures, a different set of standards exists. So I'll give you an example. If you asked 1,000 lawyers, heck, if you asked 10,000 lawyers, whether or not when a party is being sued and they ask the party that was suing them for all of the evidence that supports their case, every single attorney that you would ask would say, absolutely, if you're going to sue someone, then you have to know that you're going to be asked certain questions in the discovery process, and the plaintiff or the proponent of that case is absolutely going to be required to produce those documents. And even more specifically, if you were sued in a contract or breach of contract case, and the party that you were suing asked for the documents that support your damages, there's absolutely no question but that in every single case, a judge would say, yes, you don't get to sue somebody and then not produce the amount that support the damages you're claiming from that party. And yet in foreclosure cases, frequently we see this. Now, I am accustomed to the most grossly abusive discovery tactics that maybe exist in all of civil litigation. It happens all the time, and quite frankly, the reason why it happens is because the judicial system has set up a different standard for defendants and those that practice in foreclosure defense and across all of civil litigation. And the documents that I'm going to share with you right here are going to be real big examples of that. Now, Wells Fargo sued my client, and as they sued my client revealed there were certain problems with the case, amounts due and owing, and things like that. And so what we did is very early on ask some very specific questions about Wells Fargo's case, asking them to prove that they had standing, asking them to prove the amounts that they claimed were due and owing, all these other things. Again, very basic, substantive discovery that was targeted very specifically at this case. Well, again, in all of civil litigation, the party on the other side of that discovery would have an obligation to act in good faith and provide that discovery. Well, that didn't happen in this Wells Fargo case. You see, Wells Fargo at first didn't want to produce anything. We had multiple hearings on motions to compel, produce the documents, that sort of thing. They were ordered to produce. And then as we got towards trial, literally on the eve of trial, Wells Fargo, in response to orders of the court, starts to produce documents. And on my doorstep here at the office, literally the eve or the night before trial, we start receiving certificates, CDs that have documents on them. Now, what I'm going to show you here is absolutely unbelievable to anybody that practices in civil litigation, but I want to show you what this is. This is one of the pages, and you'll see there from top to bottom, it's a page that has absolutely no text on it at all. It's completely redacted out. Now, what in the world could be behind those big black boxes? We'll never know, but that's an example of what was produced. The night before trial, or very shortly before trial, 3,028 pages or so of documents are dumped on my office, many of them that look like that, but then hundreds of pages that look like this, completely white. So we've got this paper, we have this paper, white, one after the other, again, another white paper, and then one that I really like is because it's really an example of the gross abuses that occurred in this particular case, and that is this piece of paper. You see, this paper, you can tell, was produced in response to discovery by Wells Fargo, and it's completely blacked out from top to bottom. And in the 3,000 plus pages of discovery that were produced, there were hundreds of pages that looked just like this. Now, what in the world, in the context of a foreclosure case, would possess Wells Fargo's attorneys to produce a document that looks like this, completely blacked out from top to bottom? And how could this be anything other than a gross abuse of the process? Now, one of the compelling things about this is, you know, a party that really wants to engage in games and really wants to try and, you know, frankly, abuse the other side is to do something like this. Why? Because it burns out toner cartridges. So it's just sort of a funny kind of in-your-face thing to say, ha, we're going to burn out your toner cartridge. Another example of it, just like this, you know, one block after one block of just nonsense, utter games. And again, keep in mind, these were dumped on us literally the night before trial, so we didn't have a lot of time to get in front of a judge and bring this in front of them. But here's something that I found really, really offensive about this whole episode. And that is the second page of the discovery that was produced is this thing that I'm showing you right here. It's an award that Wells Fargo apparently handed out to whomever produced this discovery. It's a Service Excellence Award. It says, the law department is proud to recognize and thank you for consistently going above and beyond job requirements and making exceptional service the rule when dealing with team members, clients, and customers. Issued from the law department on February 2014. Yes, sir, ladies and gentlemen. Wells Fargo was so proud of the discovery that they produced in this particular case that they handed out an award to whatever employee did that. Now, this example is so bad of what Wells Fargo did in this particular case that I had the examples of the discovery produced on boards like this. And as I went into the hearing before the trial, I had about 6 of these boards blown up like this, which show what those discovery production looked like. You know, I had the entire box of all 3,000 something pages printed out and was sitting there on the desk. But unfortunately, sometimes you can't get judges to really pay hard attention to things. You need visuals like that to kind of stick it up there. So in that courtroom, I had on easels, you know, 6 boards like that. I was hopeful that I would get the judge's attention to show just how abusive it was and that he might sanction Wells Fargo somehow. Now, the trial was scheduled for that day, and the judge declined the opportunity to sanction, but they got the ultimate sanction because while Wells Fargo was busy playing games like that with discovery, they were ignoring the far more substantive and important parts of the case. And as we proceeded to trial, in a very interesting and exciting trial, it was revealed that, well, they did reveal all this garbage that was worth absolutely nothing and was just a discovery abuse. What they did do was fail to disclose the substantive and fundamental parts of the litigation that were critical in that case. And so when they got done with the presentation of their case, I'm very excited to report that the judge entered a judgment in the defendant's favor. That's right. The judge could see through all of this, a good judge reviewing all the facts, and he said to Wells Fargo, sorry, you're going to play games like that? You're not entitled to a judgment in my courtroom. Now, it gets even worse. You would think that in face of that kind of abuse and recognizing what they had done wrong, Wells Fargo might just take their lumps, go back to the office, and do it all over again. But no. Wells Fargo, in fact, has filed an appeal in this particular case. We have yet to see exactly what the issues that they might be appealing are, but it strikes me as grossly arrogant to think that they would pull these kind of games in a foreclosure case and then have the arrogance to appeal the good judge when, faced with this kind of abuse, he grants a judgment in favor of defendant. Now, suffice it to say, when we get those pleadings from Wells Fargo, I'm going to make sure that these are out here and that everybody can read them. I frankly can't wait to see what Wells Fargo and their crafty attorneys are going to write about this case and explain to the appellate court and to the trial court in all of America why it was that even in the face of their gross discovery abuses and the gross treatment of this particular case, why it was that the good trial judge was wrong in not granting the defense a verdict. Now, again, once I finally get those pleadings, which we're anxiously awaiting from Wells Fargo, I'll make sure that we share those once they become public documents. And, of course, once we get all of our pleadings framed up, and, of course, we're going to have lots and lots of examples that we'll share with the appellate court about their completely white paper, their completely redacted paper, and their completely blacked out paper, and their funny little boxes. I'm hopeful that when the appellate court sees this, they'll start to understand the kind of abuses that we're dealing with down at the trial court level. Now, one final point about all this. You know, the Dodd-Frank regulations that were recently passed provide new requirements on all banks and servicers in dealing with consumers. And quite frankly, the Dodd-Frank regulations, in my mind, produce good faith obligations on the part of these national servicers to act with good faith and engage in responsible litigation and responsible conduct in front of the courts and, frankly, in front of consumers. You know, keep in mind, these banks are not private entities that operate just by their own good graces alone. The banks and institutions operate via charters and licenses from the federal government. And part of what you see within the new Dodd-Frank requirements is some recognition of that fact and some recognition that if you're going to use the public purse, federal tax dollars, federal regulation, and use all the benefits, get all the benefits from that kind of regulatory scheme, then you have an obligation to treat consumers with good faith and fairness. This case I'm talking about here is an example of even in the face of the new Dodd-Frank requirements, we still have gross abuses that are occurring all across the state, all across this country. We can only hope that when continue to be presented with these kind of examples of abuses, the banks may kind of back off and start to take their responsibilities to consumers and citizens and to the regulatory bodies far more responsibly.